Hello, everybody. Welcome to my live. We're at Hump Day Wednesday, so hope everybody's having a good week. All right, what are we going to talk about today? Well, we've talked about medical waivers before, but I want to get into a little more detail about what kind of conditions need a medical waiver, what the procedures are for applying for it, and whether or not, for example, there's a qualifying relative that's needed. And then what I'll do is I'll go back, I will answer all the questions you have regarding immigration, and then we'll call it a day. All right, so let's get into it. So when someone has a communicable disease, they generally are going to need a medical waiver, or they are not going to be allowed in the United States. Okay? And what is a communicable disease? Well, it's something that's infectious, basically. Okay? Not all diseases that need a waiver are infectious, but generally speaking, if you have an infectious disease, like tuberculosis, something like that, then you're going to need a medical waiver in order to be able to come in the U.S. Now, of course, there's the 212D3 non-immigrant waiver, which that would be available, if you're, for example, coming to get treatment and so forth. And that's a subject on how to do the non-immigrant waiver for a medical waiver or a medical condition for another video. This particular video is referring more specifically to getting the green card, coming in as a lawful permanent resident and being inadmissible because of your medical condition and thereby needing a medical waiver in order to proceed forward. So first things first, a lot of people think that when they're applying for a green card, all they have to do is say, yeah, hey, I need a medical waiver, and it's automatic. And by no means is it automatic, okay? It is in the discretion of the officer who is ruling on the waiver whether or not to grant it or deny it. So it needs to be full, complete, persuasive, and it needs to give reasons why the officer should say yes. Because understand that whenever you're doing a waiver, medical waiver, criminal waiver, fraud waiver, all kinds of waivers, that is the door that needs to be open for you to come into the U.S. You could have the most perfect green card petition on the planet, but it's not going to help you if you're inadmissible and your waiver is denied. Okay, they won't even get to that point. So first, with a medical waiver, you need to have a qualifying relative. If you don't have a qualifying relative, you're not going to be able to do the waiver, okay? So generally speaking, if you have, and there's ways around this, but generally speaking, if you have a medical condition where you're going to need a medical waiver and you're being petitioned by an employer, you're probably not going to be able to get the waiver because you don't have a qualifying relative, U.S. citizen, lawful permanent resident, spouse, and so forth. And because of that, you'd have to go other routes to try to get into the U.S., in order to try to get that waiver, because you're not going to be able to get it if you don't have a qualifying relative. It doesn't matter how good your waiver is. If you don't have a qualifying relative, okay, which is a lawful permanent resident or U.S. citizen, generally a spouse, but not always, then you can't come in. So now what you have to show is not only, we'll talk, let's say, for example, it's a spouse petition, okay? Not only do you have to show you have a U.S. citizen or lawful permanent resident spouse, you have to show the hardship they will suffer if you're not allowed in. Okay, that's a necessity. That's part of the waiver. If you can't show the hardship, then you can't get the waiver. So keep in mind, it's not just having the spouse. You can't just say, I have a U.S. citizen spouse, and she or he will miss me if I'm not in. Okay, that's not showing hardship. Okay, you have to really break it down. Economic hardship, medical hardship, psychological hardship, all the different kinds of hardship that your spouse would suffer. I even, in many instances, will get a psychological evaluation showing medically and in the opinion of the psychologist why the hardship is so severe. Okay, so that's the first thing. The next thing with a medical waiver is you need to have medical documentation. Okay? You cannot just say, I have blah, 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 whatever it is, and think that they're going to believe you. You have to understand with immigration law, first of all, they think you're lying about everything. So you have to prove it in the beginning. So get the proper medical documentation to prove what it is you have. That doesn't mean get 700 pages of your medical file and attach all 700 pages because you think if you do that, it'll make your case better. It doesn't. You understand that an officer who's reading the waiver that you or your lawyer spent 6 hours or 10 hours preparing, they will basically spend 5 to 10 minutes reading it, and from there they will make a decision. So you cannot think that if you attach 700 pages of your medical file that makes the case better. It doesn't. Okay? What you need to do is get the cogent parts of your medical file which show what you have, and get a letter from a doctor verifying it. Okay? Now, you will also need to show that you have a plan for treatment of this particular condition inside the United States. And that would require both medical documentation and a letter from a doctor inside the United States. So generally, when you're doing these medical waivers, you will have documentation from outside the United States, and you'll have documentation from inside the United States. So hopefully you can see, which is what I'm trying to convey here, that it's not easy to get a medical waiver. It's easier than other kinds of waivers. Okay, there's other waivers that are considerably more difficult, but that doesn't mean it's easy. Some people, when I say that, all they hear is it's easy to get a medical waiver, and that's not what I'm saying. I'm saying it's easier than other types of waivers. Okay, there's actually waivers that are actually easier than a medical waiver, but what you have to do is have all your ducks lined up, have all your medical documentation, have all the evidence showing that your qualifying relative will suffer hardship if the waiver is not granted. And then if it's all granted, you come in, you get your lawful permanent residency, and of course you follow up and get the medical help that you need in order to minimize getting anyone else infected, and also to help you get medically better. Okay? All right. So let's scroll back to the beginning here and see if anybody has any questions. And by the way, if you do have questions, now is the time to ask. By the way, yesterday, as some of you know, I've been licensed in California for 30 some years. I got licensed in 1992. What is that? 2022, 23, 24, 25. Oh my God, that's 33 years. Almost to be 34 years. Holy cow. And I got licensed in Texas about 7 months ago. And as of yesterday, I officially got licensed in Michigan. So I cover the top part of the United States, the bottom part of the United States, and the western part of the United States. And then, of course, with immigration law, I'm allowed to take clients and practice anywhere in the United States. But it's still nice to actually be licensed in those areas. All right. Enough about me. Okay. Let's see what questions we have. Okay. This is from Lottie. I don't understand. Some of these are initials, so let me try to get it. So X has Ida. I think what you might mean, well, let me read the whole question. X has Ida, went to prison for drugs, around 2010, served over 1 year, and was supposed to get deported and is now married. Okay, let me translate what I think that's saying. You're saying that I don't. I guess since you're asking the question, Lottie, it must be your husband, right? So your husband served many years, it seems like, for drugs in 2010. So I don't know if your husband, if it is your husband, is still in jail or not. And I don't know what exactly the drug offense was, but I can assume that it's not just simple possession, because very rarely is someone going to get 10 years or more than 1 year even for simple possession. So it's probably trafficking, manufacturing, selling, one of those three, which makes your husband an aggravated felon, okay? And what you're thinking is now because he's married, and I'm assuming to a U.S. citizen, that they're going to allow him to get married, or that there's a waiver available. And I'd have to look to confirm, but based on at least what you're saying here, that's unlikely. He's an aggravated felon. And an aggravated felon with a drug offense, that's sale, trafficking, or manufacturing, they don't qualify to adjust status based upon being married to a U.S. citizen. So he may have to do criminal relief. I don't know if he pled guilty to this or not. If he pled guilty and they didn't properly give him his immigration consequences, he might be able to get it vacated or reduced to something that's not an aggravated felon. And if that's the case, he might qualify then for a waiver based on marriage to a U.S. citizen. Okay, but I'd need to see to make sure. All right, let's scroll down some more and see what we want. So, Mohammed Tariq, it has a thing here to invite you as a co-host. I don't have co-host, but I do give consultations. So if you want a consultation, let me know. Okay. Still scrolling. Okay. Well, this is from Lottie again. This is part 2 of the question I just answered. From Guinea and wants to travel outside the United States. His previous applications have been refused. Well, that would be a terrible idea, Lottie. An absolute terrible idea. I mean, if he wants to travel outside the United States and never come back, fine. But he's an aggravated felon. He has a deportation order. He doesn't qualify to adjust. And by sending him outside the United States, you may as well send him to Antarctica. Okay? A real bad idea. He needs to try to resolve his immigration status here while he's in the U.S., because if they deny it, you can appeal or do motions to reopen and all that while he's inside. You can do motions to stay the deportation. There's all kinds of stuff that can be done. But once he goes outside, all they have to do is see he has a deportation order. They need to just run his criminal check and see all the crimes he has, or the one crime that makes him an aggravated felon. Okay? So if I haven't said it before, a real bad idea for him to want to travel outside the U.S. unless he doesn't want to come back. Period. Okay? And now it says invite Key Link Carolina to co-host. Well, again, I don't co-host, but if you want a consultation, why, let me know. And I will give you a consultation. Okay? Now, there's no attorney-client privilege, because if you want a consultation while I'm on live, everybody and their mother can watch it, okay? Which is a little different than if you're sitting in my office or getting a Zoom consultation, just so you know. Okay, so you implicitly would waive the attorney-client privilege. All right. Lottie, this is Lottie Day. This is the third question in a string of questions from Lottie. We have a child. We don't want to get child's hopes up. Oh, do you have a child like in Guinea or in the U.S.? Because what is not wanting to get the child's hopes up, saying that, the child hopes that his daddy can become a resident or a citizen? Or is the child in Guinea and the hope is to get out of Guinea in order to come to the U.S.? How old is the child? Why wasn't the child previously petitioned, and how can you prove the child is actually your husband's child? Because if, he's been here all these years and the child is in a different country, the first thing immigration will think is it's not really his child. So you may have to do a DNA test, but minus that, there has to be a way of trying to petition, which it might be a stepchild petition. Okay, if you, Lottie, are a U.S. citizen and you're married to this guy, you might be able to do a stepchild petition. The question is, with a stepchild petition, if the primary beneficiary, which is the husband, doesn't qualify, can you still do the step petition? And there's some issues there. Okay, there's always issues in immigration. All right, let me... well, there's lots of ones that are saying invite as a guest. This is Dr. Dennis Bapan to join as a guest. Well, Dr. Dennis, if you want a consultation, let me know. Okay. Scrolling down. And here is invite creative illusions photo. So, again, same thing. Wow, I have so many people that it says to invite as a guest. Here's Ray Santiago. Do you guys all have immigration questions for me and you just want to ask it live? Let's see. There's Chico305 wants to be invited. Okay. We have lots of people that joined, but I'm just trying to see. Oh, Coco Rico. They want to join. All right. Well, Lamin Barrel just got the number 2 gifter badge, which makes me believe, Lamo, you have a question for me, but I don't see the question. Okay, let me just see. Just scrolling to make sure I got it all. Okay, here's a question from Not Niel Kelly. What will happen if we are in appeal pending and report to ICE? Nowadays I live in Virginia. Okay. Well, let me tell you, with today's day and age, minus the fact that you have ICE acting like the Gestapo and violating the Constitution up and down and not knowing anything about the Constitution. I mean, there was a report yesterday that an ICE agent pointed a gun at a U.S. citizen and threatened to kill the U.S. citizen because he was a liberal. It just blows your mind this stuff's happening. You can't make it up, okay? You cannot make it up. So to answer your question, Nathaniel, if you have an appeal pending, the first issue is whether or not you have an automatic stay of deportation. And it depends where you're appealing and what you're appealing. For example, if you lost an immigration court and you appeal to the BIA, the Board of Immigration Appeals, there's an automatic stay of deportation. But if you're doing a labor certification application and you appeal to BALCA, there's not such an automatic stay. If you do a motion to reopen and appeal, there's not an automatic stay. So I need to know what part of the immigration process you're in, because if you do not have an automatic stay of deportation, they absolutely, positively can take you and can deport you, even if you have an appeal pending. And in many cases, if they were to deport you, that by law would terminate the appeal. Okay? So if I were you, I'd contact an immigration attorney such as myself. I would find out if in fact there is an automatic stay of deportation. If there's not, I'd file a motion to stay the deportation and do all this before you have to report to ICE. Because if you can get that automatic stay or a stay of deportation, then once you report to ICE, you'll be in a much better position. You should also take an attorney with you. Okay? That's how it goes. Because I guarantee you, a whole lot of the ICE officers have no idea about immigration laws and stays and this and that. They'll say whatever they say. So you have to be prepared with the law to protect yourself. Okay? All right. It's been almost 1 year, and this is not the okay. I mean, almost 1 year. I assume you're saying since the appeal was filed. That's not unusual. That still doesn't tell me what you are appealing. Okay. What if I miss it? What are the consequences? Well, Nathaniel, if you don't go to your scheduled time, that's like giving the finger to ICE. Okay? You have absolutely violated the order of immigration to appear at your scheduled hearings, and they will come after you, and even if they don't deport you, they'll likely put you in detention. That would be the worst thing you would want to do. Okay, today, some of the questions are absolute no's. Okay, no, no, no. Don't miss it. Take care of business, but don't miss it. Seriously, okay? Moral. Applied for I-485, February 2024, completed 1 year after asylum, October 2024, still waiting. Okay, well, I'm assuming that you qualify, okay, and you sufficiently and actually got asylum. And now it's still not too long of a wait, to be honest with you. I mean, if you applied in February, now it's October, it's not even a year yet. In immigration terms, that's not that much. Okay? So, I mean, I'd wait longer. At a certain point, if nothing has happened, you can file and prepare a writ of mandate, which is suing immigration to make a decision. Okay? This is from UK 123456. Is DOS, Department of State, required to send petitioner back after terrorism denial? Well, it's not a matter if they're required to send him back or not. I mean, if whoever this is you're talking about applied for a visa of some sort and was denied because he was inadmissible based on what they believe to be some terrorism charge, they're not going to let him in. It's not that they are required. And I know you're saying, are they required to send the petition back? No. The actual petition itself is not required to be sent back. If they have a denial and it's an incorrect denial, and let's say, the guy has a similar name to someone who's on the terrorist list, then you need to do a motion to reopen or other things in order to get him in, okay? Or her in, whatever it is. Okay. Denied in 2016, petition started in 2012. So you're talking about an I-130 that was denied because of a terrorism charge. And if that is wrong, then you've waited all these years for nothing. So it would be a good idea for me or some other immigration attorney to determine how they came upon the information and decision of denying this person because of some terrorism charge. Is it because his name? Is it because it's from the country he's from? Are they just pulling at straws? Okay, there needs to be some coherent actual basis for the denial. And if there's not, because I've seen a lot of these, if there's not, you need to do various motions to reopen. If that's denied, appeals to get it approved, so you're not waiting all these years for nothing. Okay, and the fact the FOIA doesn't give you any information is all the more reason that it might have been arbitrarily denied. Okay? So give my office a call. Don't just go year after year trying to go in circles and find things out. Have it done by someone who's a professional. Okay? Ultimately, at the end, it'll save you a lot of time. All right. Well, I think that's going to do it for today. I want to thank everybody for coming to my live. Hope you enjoyed it. Just give my office a call if you want to continue the consultation. Thank you, Junie. Said I did a great job. Appreciate it. All right. Everybody have a good day.